job, without further ado, to introduce our panelists today. We're really lucky to have three panelists that are very much experts on the topic of innovations in the delivery of legal services. They've also all traveled to come be with us here today, so we're quite happy to have them with us. What we're going to do is have each panelist speak for maybe about 15, 20 minutes, then we'll have time for questions at the end. And what I'll do is I'll just give quick introductions for everybody beforehand so you know who they are. So our first speaker is going to be Malcolm Mercer, who is a bencher of the Law Society of Upper Canada, chair of its Professional Regulation Committee, and co-chair of its Alternative Business Structures Working Group. He's also past chair of the CBA Ethics and Professionalism Responsibility Committee and was very much involved with the CBA Futures Initiative and also with their initiative on conflicts of interest a few years ago. He's also, in addition to that, acted as intervener for the Canadian Bar Association before the Supreme Court on the McCarthy case, which was a big case on conflicts of interest, and has been included as the top 25 most influential lawyers for 2014 by Canadian Lawyer magazine. And when he's not doing all that, he's also a partner at McCarthy's and its general counsel in its Toronto office.
So I'm kind of hoping there's going to be a top 60 over 60 category soon. What I want to start by saying, if I can get my iPad the right direction, is to note that the topic, as you know, is innovations in the delivery of legal services. And I want to admit two things at the outset. First of all, I'm a bit player on the panel because we've got two actual innovators. I don't do anything that's innovative in the provision of legal services. My perspective is a regulatory perspective trying to encourage and facilitate innovation, but I think it's important to recognize that the real innovators are not the regulators. They're not people like me. The second is personal. I was a software engineer in the 1970s. And so I do have a little bit of a background like Monica, but the difference is I saw no future in computers and so went into law. And so with those two caveats about what I'm about, I want to talk about alternative business structures, which is what I've been spending a fair bit of time thinking and working about in the last couple of years. ABS, to use the jargon, is very much about finding ways to encourage innovation while at the same time, and this is important, maintaining the standards that the law societies, the regulators are obliged in the public interest to protect. So what are the existing business structures? I think that's important to understanding what an alternative business structure might be. In Ontario, lawyers who serve individuals, and that is mostly my interest in this discussion. I'm not so interested in lawyers serving big businesses. Lawyers who serve individuals do so primarily, perhaps overwhelmingly, in sole practice and in small firms. Individuals in Ontario are not served other than by what you'd call in another sector, small business. Individuals receive legal assistance really in five separate categories. They overlap because lawyers who provide the services often provide more than one service. But overwhelmingly in Ontario, individuals receive assistance in criminal law matters, personal injury matters, family law matters. Those are the litigation areas. Noel Semple, who writes thoughtfully about this, calls these the strife areas. And in the other two, real estate transactions and wills and estates matters. If you're a practicing lawyer in Ontario in these areas, you tend to think of the first three as the litigators and the last two as the solicitors. So how do lawyers provide those services? I think we should think of lawyers, as law is currently practiced in Ontario, as essentially small professional consultancies. What lawyers do in these areas are to speak with the clients, learn about the nature of the client's problem, spending time on learning the client's needs and wants, and then lawyers spend time figuring out how to solve clients' problems, and having figured out how to solve the problems, they then spend time doing that. Now, lawyers complain bitterly about the ubiquitous billable hour. That, to me, is inevitable because the nature of the professional consultancy is to spend time solving problems. And it's no surprise if you spend time solving problems that you're going to end up charging by the time or something that is proxy for time. So let's think a bit, if that's true, about what time costs if you're a small business professional consultant. Let's imagine that there are 150 or 1,500, 1,500 or so hours available in the year for you to be doing client work, taking into account that if you're running your own small business, you're also spending time marketing, you're also spending time billing, you're worried about your trust accounts. You probably, as a small practitioner, have something in the range of 1,500 hours to spend on client problems. Now, let's say you want to earn the median lawyer income in Ontario, half above and half below. That's in the range of $115,000 a year. Now, one can think about whether that's too high or too low, but it is what it is. And we should think about that. If you have no overhead, if you have no expenses, that billing rate works out to $80 an hour. Let's imagine, though, that you have overhead. The idea that you don't have overhead and you don't have expenses is just stupid. So let's imagine that you have $90,000 in overhead, taking into account rent, taking into account an assistant. You might be able to lower that if you work out of your home. You might be able to lower that if you do all of your typing yourself and you don't have any assistance. But let's just imagine that it's $90,000. And that's not atypical. That means a billable rate, to make this make economic sense, of $160 an hour. Why does that make sense for lawyers? Because lawyers are smart people. They're well educated. They've got an undergraduate degree. They've spent 3 years in law school. They've spent time after law school qualifying. They have market alternatives. If the market doesn't pay lawyers enough for that to make sense, for them to continue in law, you'll have fewer lawyers, and over time the market will correct itself. So what do we learn about the small professional consultancy? We learn that the natural pricing of the small professional consultancy for smart, well-educated people with market alternatives is price that's measured in hundreds of dollars per hour. That's a really important observation. It's a simple observation, but it's an important observation. So then the question is, how many real people can afford a large number of these units of production? Let's think about somebody in criminal law. Let's think about somebody in family law. Let's think about somebody in the personal injury world. How many of you in the room, how many of the speakers, could realistically expect to pay for tens or hundreds or thousands of these units of production? And the answer is damn few of us. Most people faced with this conundrum in family law start with a lawyer until they either run out of resources or they decide that the cost benefit of these hundreds of dollars of billable units isn't worth the price of admission for them. So what's the result? How do we look at law as it's perceived by real people in Ontario? 70% of people who are in family law disputes don't use lawyers. Many of them start with lawyers and then they give up. 1/3 of people who have what they perceive as legal problems, and the big five are what most people perceive as legal problems, 1/3 of real people don't use lawyers at all for what they understand to be legal problems. 40% of injured people don't go to personal injury lawyers, don't go to lawyers at all, they go somewhere else. 60% of Ontarians don't have wills. Maybe many of them don't need them. 70% don't have powers of attorney for personal care. My point is that this small professional consultancy only works where the problems are big enough to justify the expense. And for big corporations, big organizations, their problems are economically big enough, worth enough, to be able to have this sort of business model applied to it. In family law and criminal law and personal injury law, the problems are big enough to merit this sort of business approach. Economically, perhaps not on the family law side, but real people don't have the resources to spend even if the problem is big enough. to merit the expense. So the core thought that I want to communicate to you is, given the way we provide services, which is by expensive people spending time, many of the problems in real life aren't big enough to be solved in this way economically. And many of the people who have problems that are to be solved can't afford to pay the prices that are thrown off. This is part of the reason that over 85% of what are described as justiciable problems in Ontario don't involve lawyers at all. I think that's partly a marketing issue because people don't know they have a legal problem. But I think more importantly, the cost structure of the way we provide legal services just doesn't make sense in terms of most legal problems. Most people just lump it, to use the phrase. And ironically, given that, the Law Society, under the Law Society Act in Ontario, doesn't permit anyone other than a lawyer or a regulated paralegal to provide legal services in these areas where lawyers and regulated paralegals aren't, for the most part. So we have a terrible irony. So what are the answers? One answer is legal aid, and people worry that sometimes ABS pushes out the debate about legal aid, but I want to make clear why legal aid is a limited thought given the range of problem. We've just had a big announcement about a big increase in legal aid. So for a legal aid certificate, by 2016, now if you have an individual income of nearly $13,000, you can get legal aid. Let's understand that's important for people in that income range, but let's think about what the majority of Ontarians who now can't afford lawyers, what income range they're in. For duty counsel, by 2016, it'll be $21,500 roughly. Let's imagine all of the Ontarians who have family law problems or criminal law problems who have incomes over $21,000, and we're only talking about duty counsel. Let's talk about community legal aid clinics, and the increased amount for 2016 approaches $19,000. I don't mean to diminish that at all. That's really important. It's an important use of social resources. My point is that we have a market which is about legal services that isn't just about that part of the market. Let's talk about pro bono. Pro bono is an important aspect of achieving increased legal services, and yet what it really is diversion of revenues from one part of the model to another part of the model. If we can't get pricing below hundreds of dollars per hour, we're not going to, even on a cross-subsidized basis, we're not going to materially expand. So the question is, how do we actually make a difference here? In the rest of the real world, cost is not just labor. Cost is not just a consulting model. Cost is brought down, and therefore pricing is brought down by the application of technology and business process engineering. You know, if you listen to the innovators, what they're trying to do is find ways out of the billable hour, the professional consultancy paradigm. Why does that not happen naturally in a world which is made up of small professional consultancies? And the answer is there are two types of capital required to take advantage of technology and to take advantage of business process engineering. You need economic capital and you need social capital. Small professional consultancies only have legal expertise. They don't really have business expertise, technological expertise, marketing expertise, and the other expertise necessarily to do things differently. Small professional consultancies only bring the legal expertise of their owner consultants, and they tend to be generalists because they're small businesses. They tend not to come together and provide the rare general or the rare specialized expertise. They do real estate, they do estates, they do personal injury, they do family law, etc. A small business can't take a big risk. A small business can't decide to develop the iPad. A small business can't create Ford's magic of the assembly line in the 1920s. And that's because none of us would put our personal wealth at stake, because most important things fail. And if you know that most important things are going to fail, you're not going to put all of your resources on the line. You might once. It's tough to do it a second time. So what's changed? Why is this interesting now? Think back to the 1970s, and you can't, for the most part, but I can. In the 1970s, we had mini computers. When I started practice in 1984, the PC hadn't yet arrived. It arrived the next year. I got one. It was very cool. Fax machines arrived soon after. By the late 1980s, we had email within the office and sometimes between offices. It was astounding. In 1994, I remember connecting into the tech web, the text web, which before graphics were there, but we started to communicate by email. By the late 1990s, we had ubiquitous email. By the 2000s, we started to have goods and services delivered from everywhere to anywhere. We had Amazon delivering products. We had a variety of different ways of connection. This radically changes the ability to deliver services compared to when I started in practice. It radically changes what's possible as compared to 10, 15 years ago. So the question is, and it's an unanswered question, given the problems that exist or the limitations which exist with the legal service business model, the small professional consultancy, can, with expertise, the evolution of technology and capital, can we actually start to do things differently and expand what is being provided to real people? And I want to give you an example which goes back to me as the troglodyte that I'm trying to portray myself as. In 1972, I worked for the IBM lab as a co-op engineer from Waterloo. I was making, I think, I don't remember what I was making, it was tiny. I worked for H&R Block part-time at nights to be able to pay my rent. I had a new capital-intensive instrument which is just then available called a calculator. And that sounds ridiculous, but it wasn't available the year before. It was amazing to be able to sit down with a calculator and learn from somebody what their tax information was and fill out the form by hand using a calculator. So that's a professional consultancy that's slightly capital enhanced. Those suckers were $500, as I recall. What do we do now? We now go to TurboTax. We download it from the internet. It asks us a bunch of questions. It has tax intelligence inside it. And it costs less than I would have done for a single tax return by a fair bit. So I think that lawyers do a great job in court. I don't believe that you're going to have machine intelligence plead a case better than a lawyer does. But in the world where now predictive coding is part of the reality, where Quicken TurboTax is part of the reality, where Quicken family law has been banned in Texas because it's unauthorized practice of law, are there ways that we can bring new resources, new expertise to expand what can be provided at a cost which actually makes sense? And the only way that you provide pricing or cost which reduces, I think, is by changing the means of production, changing the way services are provided. This is scary stuff for lawyers because they have established practices, they're afraid of losing what they've created, which is of value, and I've got complete sympathy for that. But there are huge swaths where we're not effectively and efficiently providing service. And the question is, should the regulator continue to effectively ban innovation by effectively banning the application of new capital, human capital and economic capital? And that's the question.